Good afternoon, everybody, and welcome to the webinar on the reality of tokenized private assets. I'm Daniel Barron. I'm the Chief Legal Officer of Invenium Capital Partners, and I am privileged to be joined by an all-star team of world-leading experts in this emerging space. And I'd like to first begin by giving everybody the opportunity to introduce themselves. Um, Troy, we'll start with you. Welcome and thank you very much for joining. It's a privilege to have you.
Great, thank you. So, Troy Pratis. I currently have my own consulting advisory practice, Pratis Strategies. Prior to that, I had been a commissioner at the Securities and Exchange Commission from 2008 to 2013. And I had earlier in my career been a professor of corporate and securities law, and at one point, way back in the day, had been a corporate lawyer. So it's great to have the chance to be here today, and I'm looking forward to hearing what the other panelists have to say.
Great. Thank you very much. Abradat, welcome to the webinar.
Thank you, Daniel, and thanks for having me. Abradat Kamalpour, partner at Jones Day, based in the San Francisco office, in the financial markets practice, very much focused on all things fintech and digital assets.
Super.
Great to be with you.
Laura, welcome.
Oh, thank you. I'm Laura Pruitt. I'm in Jones Day's financial markets group in the Washington, D.C. office. And I represent brokers and dealers, exchanges, trading systems, essentially anything under the Exchange Act. And I previously was on the staff of the Division of Trading and Markets at the SEC.
Okay, so we are privileged to have two SEC alumni among us. Ami, welcome.
Thank you. Hello, everyone. I'm Ami Ben David. I'm the founder and CEO of Onera. We are an interoperability network which provides distribution and liquidity for the market of digital securities, especially, but not only in private markets. So we operate in other markets as well, bonds, repo, and so on. And basically what we do is we interconnect the myriad of various platforms that are used to tokenize assets on different tokenization platforms and solutions, homegrown systems within big banks, custody providers, trading platform buy sides, each one using different platform and need an interoperability layer that can connect them to enable trade.
Great, thanks. Welcome, Luke from Tokeny.
Hi, everyone, and thank you for having me. So I'm Luke, I'm the CEO at Tokeny. So we are a tech provider, actually. So I'm not a lawyer, but I will do my best today. So we help financial institutions to tokenize their assets, to represent their assets on the blockchain. We help them to issue, to manage, and to transfer these assets in a compliant way on DLTs. We do this since 2017. So we have seen a lot of different use cases, and we've seen the regulatory landscape changing over time. So I will try to share my insights today.
Okay, thanks. And again, I'm Daniel Barrett of Invenium Capital Partners. Invenium has built a platform with proprietary technology, and we believe that we are the best-in-class data layer to service and to serve as the provenance and audit trail provider that belies a token and a digital asset. And we're working together with our ecosystem partners, including Tokeny and Onera, to integrate all of the different components and players in a compliant way to create an environment which improves the efficiency, the transparency, and the regulatory level of compliance in the entire industry. And to that end, I'd like to open with the first question. And that is, we share a vision of the global tokenization of private assets. Where do we stand today? What is the reality as it exists at the moment? So I'll start with Abradat, because I know that everybody has seen this in their own practices from a different perspective. Where do you think we are now?
Well, I think generally things on that side, and I exclude crypto, just general crypto from that, are going in a positive direction, Daniel. The players in this space know that they're dealing with investment instruments, securities, and there's no one trying to say that they're not securities, in many instances. Of course, the lack of regulation in some jurisdictions does create issues, and we have issues, for example, in the UK. The FCA was, frankly, I thought, quite ahead of the game with its guidance papers on what they would consider as securities and what they don't. So people had some clear guidance on that, and you could just drive your business based on that. The only issue that has been, I think, a bit of a delaying factor is this crypto asset business registration issue. On if you're an issuer of digital assets, you have to also register under this scheme, which technically should not really be a problem, right? In this space, because players in this space understand KYC, AML, but the FCA has been very, very difficult in terms of actually registering companies to do this. So that has been a delaying factor in the UK, but there's new legislation coming out. You probably saw the Treasury consultation paper about the discussion of bringing in new regulation that would allow digital assets to be regulated more akin towards current financial instruments. And I think that will help. When that comes out, it'll clarify things and hopefully will also address this issue of lack of registration under this UK crypto asset business registration requirement, which will open the doors, I think, for a lot more people to consider and push out tokenization into the private markets.
But so how, just be great if you could clarify how the crypto asset registration affects digital assets, because people sometimes have difficulty drawing that distinction, and
yes,
focusing on where the line exists, if it does, would, I think, be very helpful.
Yeah. So, for example, at the moment, if you are by way of business involved in digital assets in the UK, so issuing digital assets in return for fiat money or other digital assets, that is considered a crypto asset business. And accordingly, you just have to register, right? You have to register that. And even if you're offshore, but you're doing a lot of activity in the UK and suddenly you fall within the umbrella of this, you have to look at it very carefully. You might be required to register. And that by itself is not an issue. People are happy to register. It's just whether the actual registration will be formalized and granted. That's been the problem.
Mm-hmm. Okay.
So let's say you have a company, you want to tokenize an asset, and you're issuing digital assets, obviously, to do that. Does that fall within the umbrella? You know where I'm coming at, quite frankly, probably. So that has been an issue.
Great. And Ami, where would you see, I know that you operate in the EU, you're based in the UK. Where do you see the current state of the tokenization of private assets globally? You're on mute. Ami, you're on mute. Thanks.
It has to happen at least once. Yeah. My answer, again, I'm not a lawyer myself, so I'm not going to talk directly on the legal side, but more on the status of the market. And we can talk about our connection to the legal side later. In terms of the status of the market, we are focusing specifically on securities and bonds and other assets that completely separate from the crypto market. There's always an issuer, there's always an agent or a transfer agent or the equivalent of a transfer agent that is issuing the asset, same as you have in existing assets. And on the other side, you have a holder, which instead of signing transaction with signing a piece of paper, they sign it electronically with a crypto. But effectively, the same structure, same flows are pretty much similar to flows that we've seen before. Pre-tokenization, so very different from the world of crypto. We can talk about it some more. As to the status of the market right now, I would say this: like any market, there's an element of supply and an element of demand. I would say that for a long time we didn't have the supply and we didn't have the demand in this market. The supply was very small assets and the demand didn't exist. Today, I can say that the supply is ramping up quite fast and quite seriously. So there's a lot of supply coming in from the top kind of asset issuers, asset managers, big banks, big buy sides. Everybody is looking to tokenize. and in large number. In the last report from Citibank, they talked about something like $5 trillion of tokenized assets by end of the decade, out of which 1.5 trillion in real estate only. So that's by the end of the decade. So that's 2030. You need to go back and see how much you need to do in 2024 to reach $1.5 or $5 trillion at the end of the decade. It's quite a large number. So everybody's tokenizing. So the supply side is definitely there. The demand side is now the issue, and that's the issue that we're trying to solve with Onera, because the problem is that the supply is very fragmented. So if you have a client that wants to buy today, if they wanted to buy 10 tokens and each one of them was on a different platform, they would have to open 10 different accounts. It's very difficult. And then if they needed to use custody, each custodian would have to connect to all the tokenization engine and to all the destinations. Super difficult. So what we're doing now is creating interoperability layer, which is now bringing the demand. What I can say is that we are now in deployment phases with the largest banks, buy sides, and so on. And my estimation is 23 is the build year. We're building the pipework for the destination side, for the demand side. We're going to start seeing live transactions towards later in the year. When I say live transaction, not from the smaller player and smaller exchange. I'm talking about the major top 5 banks and buy sides and so on. And with them, you're going to get the market open and everything will flow from there, because once you have the demand, there's going to be more supply and then more demand and then more supply and so on. But I can say that the good news is, if we look a year back, we didn't have the supply, the quality institutional grade supply, and now we do. So hopefully, a few months from now, we'll have institutional grade demand as well, and that will kick the market in and start building up towards those trillions quoted by Citibank.
What type of assets do you see leading the supply side currently?
So the type of deals that we're seeing are around a lot of work around real estate, both in equity and in debt instruments. We're seeing private equity, so private funds and so on, but also private companies starting to happen again, because there was a period that this market was dead, and now it's starting to happen a little bit more. You see money market funds, treasury funds, definitely a lot of asset managers are launching those, and you're seeing bonds, ESG bonds and other types of bonds being issued, as well as intrabank activity like repo, which in itself is a multi-trillion dollars a day business. So this is another market that's, again, not private markets, but a very low-hanging fruit for tokenization because of the advantages of instant settlement, which can enable things like intraday repo that is impossible when you don't have the instant settlement. So there's a lot of activity, and it's very, very wide and varied. And we're getting, anything from, when I say real estate, we're also getting shipping and aviation. A lot of things will come, but it all depends on the institutional grade demand and the custody, and those are now being built.
And you said the demand today is very fragmented. Is it retail customers? Is it small institutions? I got the feeling, and tell me if I understood this correctly, that the larger institutions are a little slower to come into the space. What is the demand like now, specifically, players?
The infrastructure for an institutional investor to invest in tokenized assets is complicated. They can do a one-off deal with one tokenization platform, but to actually start moving their business on scale, it's complicated for them. Take, for example, a fund that buys through one custodian, right? They can't just buy tokenized assets if their custodian is not connected to the tokenization engine that they want to buy from. So the infrastructure has to be built to enable that. So what we've seen until now was tokenization and some retail activity where some people would buy directly in the same way that they would buy crypto. But we haven't seen the institutional markets, the multi-trillion dollar institutional markets move at scale. And this is what this whole industry is about. This is an industry that everybody's talking about it dwarfing the crypto market in terms of assets under management. But until we get the infrastructure built, it won't happen. And as I said, the asset tokenization is happening. So the asset side is there. It's the demand now that is being built.
Excellent. Thank you very much. Let's jump across the pond to the United States, to Laura, to sort of give us a snapshot of what is the reality today in terms of tokenization of private market assets?
Well, here, there's really a tension between innovation and regulation. There's disagreement on so many levels in the United States, both between the CFTC and the SEC in terms of who should regulate these products. In Congress, which committee, which legislation,
Yes.
That's an issue. There was some good movement last week on stable coins with some proposals coming out of Congress. So that seems to be moving a little bit faster than other tokenization matters. But, one of the problems you have here with the regulators is that, they're all used to a particular regulatory scheme, and it just doesn't fit a lot of the tokenization and a lot of the crypto assets. And so that's what you see with, for example, last week's action against Coinbase, or early this week, whenever it was, and Binance, the most recent two large cases, in that, Coinbase has been seeking guidance on, okay, how do we register? Can you have rules? Please do a rulemaking proceeding, and haven't been able to make any headway. And so you have people in the industry that want to get registered, want to do things the right way, but it's extremely difficult because, again, it's fitting a square peg into a round hole, and it doesn't fit. There are some good developments. For example, the special purpose broker-dealer. The first one was announced not too long ago, that allows a registered broker-dealer to actually custody crypto securities in compliance with the customer protection rule. And that's a start, but it's still, there are a lot of regulatory hurdles here that unfortunately may be putting the United States sort of behind the 8 ball, and other countries that are more nimble and don't have as much infighting may be able to move ahead and really impact how the industry is going to be regulated on a global basis.
No, it's an incredible summary of the challenges we're having. Troy, your perspective, especially as a former SEC commissioner, on the current state of tokenization of private market assets and the current landscape.
Sure. I think in terms of the reality, I think early days for a lot of the reasons that have been mentioned. And I think just to generalize, if I could, a couple of the points that I think others made, the importance of not only the technology infrastructure continuing to develop, but having a technology infrastructure that matches with a regulatory environment that is conducive to that technological environment. And that doesn't mean, and I'm sure we'll talk more about this a little bit later, that doesn't mean, from my vantage point, the necessity to jettison entire principles that make for sound compliance and promote market integrity. But you got to get beyond, I think, the big discussion around the details. The details of broker-dealer requirements, or the details of exchange requirements, or the details just generally of how you engage in an offering of securities. Those details matter immensely. And then asking the question, do the details match the technology in a way that not only protects investors and consumers in the marketplace and a whole array of market participants? It's good for issuers and for businesses when there's a marketplace that has integrity and that people have confidence in and can trust. That's good, not just for investors and consumers, but it's good for the overall growth of the marketplace, which creates opportunity. And I think an interesting point that I think you made at the outset as well, and perhaps others did, is thinking about the ways in which the technology itself can promote compliance. And perhaps beyond just compliance, can promote risk management by embedding elements of a compliance framework, elements of a risk management framework more broadly, into the tokens, into the technology that's being developed, can create a lot of opportunities and really create, the proverbial win-win as compared to what sometimes feels like it's an either-or discussion. which I think can be unfortunate because I don't think it needs to be either or. I do think there are win-win opportunities. But one other quick thing that gets more to the space, if you will, the reality of tokenization as such. There's the where it is, and then there's of course the where is it going. And I just want to make one point on the where it's going, and perhaps broaden out the lens on this for a moment. If one thinks generally, and if you will, historically, about conditions that can promote economic growth and the opportunity that attends it, a key part of that is the ability for parties to transact and more generally interact. And so one of, I think, the big promise, kind of big picture stuff here, is that through blockchain technology, through tokenization, through other applications and use cases, the promise that allows for more efficient, lower risk transactions, as well as just a broader set of interactions that can hopefully bring economic parties together, that can bring even non-economic parties together to interact in one way or another, trade, transact, what have you. And that as a result of that, you can create growth, economic growth, and the opportunity, again, that is associated with that. And that's just, I think, an amplification, I think, of what, I don't want to speak for Laura by any stretch, but I think, Laura, what you're getting at in terms of the practical power of innovation and technological innovation is that it creates the conditions for growth and opportunity. And that's something to rally behind in terms of the big picture of the promise as to where all this may be going.
No, I think that's such an incredible point. And I'm going to, I feel a tremendous irony because I watched some of the congressional hearings, and I've heard the skepticism about the industry, and the greatest irony is that all the problems that people are concerned about, transparency, disclosure, all the things that SEC and disclosure lawyers care about. And that's how my career began in Wall Street, as a disclosure lawyer. The irony is that the solution is blockchain. The audit trail is there, the transparency is there. Using a data layer like Invenium to take the token, which represents a security and an interest in something, and connect it back to the assets, to the paper trail, to take a tokeny and create the digital instrument that can be transferred on a compliant platform. Let's take Onera, that enables everybody to interact together. I mean, we are the solution to all the things that they're worried about. So the tension between regulation and innovation is in a way artificial, because we can solve one with the other. So, I think sort of the win-win approach is inspiring. And I guess with that, we'll go to Luke to hop back across the pond to Europe and Luxembourg, and understand where you see the current market of the global trading of digital assets is today, tokenized assets.
And I totally agree with you. What we do for 5 years is to enable financial institutions to enforce securities rules and corporate laws. So we actually don't want any new regulation. We prove that we can, via technology and via blockchain technologies, we can enforce these rules, manage risk in a better way, manage compliance in a better way, and in a streamlined way where everybody is connected to the same ledger, the same database, the same shared IT infrastructure. And depending on your roles, the different stakeholders can perform operations or not, can see information or not. So we do this for a few years in Europe quite efficiently, because Luxembourg especially said a few years ago that you can issue securities on the blockchain and the securities laws will apply. As simple as that. So we could start directly by tokenizing any type of securities. We have clients all around the world for a few years. So we have clients in the US, we have clients in Singapore. So you can tokenize everywhere. Just in Europe, it's true that you have a bit more clarity. You have less chance to get problems later on because it's clear, especially now with MiCA. So this new regulation. So MiCA says MiCA is for crypto. It's not for security tokens, but it says clearly that crypto are not securities. And if you want to do security tokens, you have to apply all of the securities regulations. So it's the only thing we needed. And thanks to that, it gives comfort to a lot of financial institutions. And now I think it's fair to say that all around the world, financial institutions see blockchain technologies as a suitable infrastructure. Governments want to push digitalization of their economies. So usually they are pretty open to push blockchain technologies. But I think because it's a new technology, people don't understand what you can do, and they don't understand that security tokens or tokenized securities are totally different than cryptocurrencies. So they don't really understand what you can do with it.
You touched it. Yeah, go ahead. I'm sorry. Go ahead.
No, I just wanted to say that that's exactly what we do, is to make sure that anyway, you have an issuer, you have authorized agents, you have investors, and all of those different stakeholders have permissions, authorizations, or not to perform things, perform actions, or to see information. And we think it's really important. So we don't intend to change how it works. It's still the same players. Just we give them tools to make their operations much more efficient, and to be able to transfer value in a digital way, to track ownership in a digital way. That's the only thing we do, but that changes a lot of things.
No, there's the very, there's just one thing, is that there's an insight that you're making, that in contrast with what we've been saying about the US, that the European regime, from your perspective, is mature. And, you know, what Micah basically said, for your purposes, is what it doesn't apply to. Which is interesting. But just one follow-up question, because I'm a director of a Luxembourg fund, and despite the EU rules allowing electronic signatures, I have one signatory bank who keeps asking for wet ink signatures. Are industry participants taking advantage of the regime, or are they still saying, okay, it's permitted, but I know that you can't relate to this in Luxembourg, but we've been doing it a certain way for many, many years, and that's the way we do it, and we're not so quick to change.
Yeah, so I think for years, financial institutions try to basically connect the blockchain to their own legacy systems, and to control the infrastructure, to launch their permission blockchains, their permission networks. So they did a lot of POC, and they played a bit with smart contracts and blockchain technologies, and now they're tired of this. Now they want to go live. So they don't talk about proof of concepts, they talk about pilot projects, meaning in production, and use cases that can scale quickly. So I think now it's fair to say that all large financial institutions is working actively on this type of project, tokenization-based project. And we provide them the tool, because otherwise they will lose years to build everything we built over the last 5 years. So they're all working on it, under the radar for most of them, because they want to make sure that they control this new value chain, that they know where is their role and what they will charge to their clients. But it is happening. Of course, when we tokenize an hotel in Bali, we have publications everywhere in the press. But the real game is not this. It's really what is happening right now with the large financial institutions, fund servicers, asset managers, exchanges, commercial banks, private banks. They are all working on concrete projects to tokenize bonds, rid of equities, a lot of funds, a lot of real estate in any shape or form. So this is really happening. So I totally agree with Amy. The supply is coming. Now it's okay, we can tokenize at scale, but what can we do with these tokens? Okay, we will definitely, with the digital securities, improve our operations. But I want new things to sell to my clients. So what can I sell? DeFi, collateralization, secondary markets in different forms. But all of this is still, we're still waiting for all of this. A lot of initiatives, a lot of things coming, but we're still waiting for
it's back to the AMI supply and demand dynamic.
I
want to, yeah, I'm sorry, go ahead.
I was saying that's exactly what we're working on right now. I think, just to add one more point to the US versus Europe, I think one of the things we're seeing is that a big financial institution want to move ahead with tokenization in the US as well. But since there's not a lot of clarity on how to do this, and the confusion between crypto and tokenization, the way that they're going is they're launching on private blockchains rather than public blockchains. And basically they're telling the regulator, this is just a database. Don't call it a coin. It's actually a tokenized depository. It's not a coin anymore. It's a tokenized depository. And it's on my own private blockchain. It's just a database. And we're using, you asked it to be behaving like a security. It behaves exactly like a security. There's an issuer, there's a transfer agent, there's a custodian. Everything is exactly the same. And blockchain is just a DLT, a different ledger at the bottom. So they can get a lot of the advantages, especially if they're connected to a platform like ours for interoperability. They get it, which effectively turns it to one big network. So you can have the advantages still by using private blockchains. And I think that the government in the US is currently pushing the institutions away from public blockchains. They can't even pay gas, right? So they just don't want to go there. While in Europe, it's much easier for some of them to go a public blockchain because they see the advantages of the public blockchain. So this is the dichotomy that you see in the market right now.
And we'll return to regulation and some of those distinctions in a minute. I want to welcome Natalia, who has joined us with Jones Day. And Natalia, it'd be great if you could just take 1 minute to introduce yourself and then give us your take on where you see in your jurisdiction the adoption of the tokenization of private market assets, which is in the EU.
Sure. Thank you. So I'm Natalia Sozin of Counsel at Jones Day. I'm in the Paris office. So I'll be talking about the EU perspective. I've been working on traditional capital markets transaction, and then quite a few years ago hopped on the blockchain and tokenization train with my colleagues Abradat and Laura. So here in Europe, it's been a busy year in terms of regulatory progress with the pilot regime and MiCA coming. And I totally agree with Luc. All the major financial institutions are looking at tokenization projects, tokenization platforms. They're all testing the plumbing. Now it tends to be mostly on private blockchains, but there have been tests. We have worked for one of the major French financial institutions on a renewable project bond on a public blockchain. So there is appetite there for testing. And with the DLT pilot regime, our EU sandbox, I think we'll see things progressing even faster.
What type of assets do you see are the most tokenized, digitized, or supplied, to use Ami's terminology, in the current state of affairs? You mentioned renewables. Yeah.
Yeah, we see a lot of renewables, real estate, and then traditional securities. Could be structured products, less structured products. Really a bit of everything, with a trend, of course, for ESG lately.
Great. So with that segue, I'd actually like to move now to the current state of regulation and look at it in a little more detail. And I think we have a very interesting backdrop of a contrast between Europe and the United States, where the Europeans believe that at least our panelists have expressed the view that the current structure of the European regulatory regime works to adapt to the new digital era. And I'll join the US panelists in expressing my skepticism about the US perspective. There was a case that called American Crypto Fed, which didn't get as much publicity, but it was almost comical because they filed an S1, and because they said, let's try to do it the right way. And they went through all the line items in Regulation FK, which is basically, instructions as to what you need to disclose. And there were a couple of them that they said not applicable. And the SEC came back and said, no, but you must disclose that. And they said, well, it doesn't apply. There is no real management. There's not actually business. And there was some back and forth. And the SEC said, well, we're putting a stop order on your registration. And the American Crypto Fed said, well, we're withdrawing it because we decided it's not a security. And the SEC said, we're putting a stop order. And American Crypto Fed said, well, you can't do that because you can only put a stop order if it is a valid registered security that's, that you've signed off on. And that's the kind of dynamic we've been experiencing. So, Laura, where do you see things going in terms of the different committees, the competition between the CFTC and the SEC? How is the regulatory regime adapting in the U.S.? And this is the week to talk about it.
Well, I think that we have to step back first and determine, is the digital asset, is it a security or is it not? And that's not as easy as just saying, as the SEC chairman says, oh, everything is a security. There are some real questions as to whether, at least with a lot of the coins, when these are traded on a platform and you are down the chain of ownership, secondary market trading, where is the investment contract? And if that's what you're relying on the Howey test for that, yes, it was a security when the initial coin offering was made, but later on, is it still? And that's one of the issues that has been before courts. It was raised in the Ripple case. We're still waiting for that decision to come down. And it was also raised in the motion to dismiss that my firm was representing one of the defendants in the Wahi Coinbase insider trading case. That matter settled, so the court never ruled on, is Howey valid, the valid analysis for those types of coins. So you have that issue, because if it's not a security, you don't have to worry about being a broker dealer or an exchange or whatever, a clearing
insider trading in the Wahi case that you're working.
Right. And so it's, you have to look at that. Maybe it's time that, again, the Howey case came down in the 50s. Can that precedent apply to this new technology? Or does it need to have some sort of congressional action? Because as we talked a little bit earlier, the CFTC and the SEC are not going to agree as to, to divide up the world on their own. And so there needs to be some legislation that can both foster innovation, but also protect investors. And unfortunately, there are also so many big problems with FTX, with a lot of other players, the Terraform, all of those. And I think that tars the industry. And so people that aren't as familiar with a lot of the concepts just hear it's crypto, it's tokenization, and somehow that's bad. Something similar happened with alternative trading systems back in 2008. Dark pools. Dark pools were the enemy. And you just get sort of tarred with a bad brush when actually, and not seeing all the benefits that can happen through it. But one of the promises of this technology is to be able to disintermediate, and you can do peer-to-peer transactions and have it be more efficient, more convenient, more transparent. But the regulatory schemes are based on the regulation of intermediaries and wanting intermediaries to be in the mix. And so it's a real tension between regulation and appropriate regulation and innovation and trying to become more efficient. So, it doesn't particularly help when people are trying, as you said, people are trying to do the right thing and they're sort of stymied on all of their efforts. And then, okay, we'll just bring an enforcement action against you. Yeah. And so that's sort of where we are now. I noticed in the Kraken order, it looked like people were not even allowed to, part of the settlement was that they couldn't even do staking if it was registered as a security. And those types of things I think are not helpful at all to moving the industry forward. But there are so many is it a broker? Even in outside of this context, that's such a gray area. And now you add additional layers of complexity to that, makes it even more difficult to apply tried and true concepts just to a totally new context. And I don't, there are people at all the regulators that want to do the right thing, but when you're grounded in doing the same thing for years and years and years and years, it's hard to, all right, we'll give it a shot and try to, like OTC derivatives dealers years ago, sort of broker dealer light. It took a long time to get that approved because it was different. And it's like, let's have a new scheme just for people that do this. That can be exempt from some of the requirements, but other ones we're going to impose. And so I think there needs to be some thinking outside the box. And I think some people are trying here, but to come up with a scheme that that fits the industry. I don't think it is a good thing to just, as the SEC has done, well, we'll just expand the definition of an exchange to fit DeFi. That's, again, I don't think that's particularly helpful, and is just going to serve to, if that's the case and every entity that's somehow connected in a DeFi platform or DeFi system is now an exchange or part of the group that is an exchange, that's an impossible standard to meet. So
I appreciate that. I wanted to narrow it down to Troy a little, because there's one layer here that really is similar to what Luke was saying in Europe, is really a security. If I take a set of real estate assets and I use an Invenium data layer and I tokenize it with Tokeny, and I have an interoperability function with Onera, and I want to engage in business in the United States using, as much as I can, the old securities regime. Where is the bottleneck if we leave crypto, aside? Is it custodianship? Where do you see things going? Because that should be a much simpler question, because it's a security like any other. Where's the challenge, if any?
Well, let me start with it's a security like any other, in the sense that I think depending upon the particular facts and circumstances, right, folks may take different views as to whether or not a particular set of facts and circumstances is or is not a security. So coming back, I think, to some of the points that Laura was making, the what is it question is the front and center question, and has been now for several years. And the what is it question is it a security?
It's not. This whole conversation is going back to the same point. The subject of discussion is tokenization of private markets. We're building a market in which we're tokenizing real estate. We're saying out front, it's a security. It behaves like a security. And we're asking the lawyers, can we do it? And time, we get back this message that, is it a security or not a security? It is a security. We are saying,
even if it's not a book entry, it's a ledger, it's an LLC membership interest. Let's assume, and I'm very sensitive to the Howey question and whether orange groves can really be applied to digital assets. But let's say that it's an interest in Invenium. It's an interest in an entity. So then what? We have some problems with custody. Where does the current regime have to go in order to adapt to the tokenization of private market assets, assuming that it falls squarely into a category? And I agree that there's a fantastic gray area.
Yeah. So I'll agree for sake of the discussion, that. Right, but I do that with some reluctance, only in the sense that there are different facts and circumstances, and folks are continuing
100%.
to different conclusions as to whether or not a particular set of specific facts and circumstances is a security, is a commodity, is a this, that, or the other, and those details end up mattering to that question, which then ends up having significant consequences in terms of what regulatory regimes do or don't apply. So that discussion is still front and center and persistent in the U.S., and I think will continue to be for some time. And it's clear that there are different views as to how to approach that, and that will work its way through and continue to work its way through. The point that I was going to get to, having acknowledged that particular point, was the next one, which is whatever it is in any particular instance, given the particular facts and circumstances, it's essential for the regulatory requirements that apply to be workable as to that particular asset. And the discussions, I think, to date oftentimes have been around the jurisdictional question, the what is it question, the what regulatory regime does or does not apply. And what's needed is, sure, I personally think that discussion is going to continue to persist, as I said. However, regardless of where that comes out, the fact of the matter is you still need to have regulatory requirements that, when it comes to the details, work and make sense in light of the underlying technology. And that, I think, is where, at that level of detail, granularity, particularity, that a lot of work continues to need to be done. You think about the context, for example, of custody and possession and control and things like that. Well, how do you think about that in a very specific way, given the underlying blockchain technology, digital assets, and tokenization, as compared to, let's just say, not that? And it's with respect to not that, the regulatory regime, both in terms of statutes, rules, and regulations, but also guidance, no action letters, exemptions, interpretations, understandings, just the way in which people have gotten comfortable. None of that developed, that whole body of stuff, if you will, none of that developed mindful of this particular technology. And so, to put a little bit of a finer point on that, and you could play that out across everything, right? Not, I just use that as one example, but to put a bit of a finer point on that, to make one last point, is the following. Imagine, and I'll just this is more rhetorical, but imagine a circumstance where regulators show up for an examination or an inspection, and they ask for the full suite of policies and procedures that one is accustomed to providing. And instead of providing the full suite of policies and procedures, you want to have a discussion around the code. That's a very different kind of discussion. And so it's just an example of the getting acclimated to the technology in a whole host of different ways that I think is very much in process. And I think where folks on this call, particularly those who have technology solutions, can be extraordinarily constructive, is that engagement, if you will, with policymakers and regulators to help them understand the technology, and not just the promise in terms of what the benefit, the business use case is, but the potential for the technology to actually meet what are legit regulatory objectives from a compliance and risk management perspective. So I think that is a part of the pathway forward, again, irrespective of what any particular asset is or isn't, and people will have their views and there will be differences of views on that. There is still the question of, does the regulatory regime in the details work? Does it fit? Is it workable? And I think it's these sorts of discussions that are really important to have as part of the process going forward.
No, that's an incredible point. And I think most of us probably would view ourselves as thought leaders in the area. And it is these discussions that hopefully will help the markets and the regulators adapt. Question for you, Burdett. We're a little short on time, but the statement has been made by Luke and somewhat seconded by Natalia, that in contrast with what we continue to hear about the United States regulatory framework, the European framework is far ahead and really there. And it's just a question of market adoption and the institutional players coming in. Do you agree with that? And also, what do you see in the UK?
I think partly. I think in the UK, there's real active movement and political will to try and drive this industry forward. You probably saw the all parliamentary working group statements about, look, let's get out here and regulate this space properly. Let's treat them as financial instruments. Some parliamentarians got together and said that we should treat, for example, crypto as gambling, and there was strong resistance. I know we're not talking about gambling here, but We still have to refine the regulation there, although it's ahead, in the sense that, for example, you made the example that, look, let's say we start creating an interest and we say it's a security, so what? Well, the definition of a crypto asset overlaps because it's a digital asset. You know, the definition of crypto asset is broad. It's a cryptographical secure digital representation of value or contractual rights that use DLT. Now, your security is a security, so it's caught by the securities regulation, but now it's going to be possibly caught by this regulation as well. So then you have the overlap, right? And you say, well,
in the UK, you're referring to the UK,
well, potentially,
because MiCA had carved it out expressly and put it on the side. So that's an interesting contrast.
UK is not in the EU, right?
No, that's why I'm saying it. Absolutely.
Yeah. So the UK itself is going to have new legislation in place that will, I think, greatly clarify a lot of these things and help things move forward. I mean, the EU, I think, is ahead in the sense that they've really given thought and designed legislation to do this. I mean, some of the VASP laws and how they're being adopted and used in different jurisdictions. And as you know, there's different regulation in different jurisdictions as well. So in Italy, you have some regulations, and it's not, it's not going to be all across the board. I'll let Natalia comment on that. But you have the general EU regulation and MiCA and DLT pilot regime, but you have localized regulation as well in different countries that you have to think about sometimes. But I would say in terms of actually getting people together, designing things and thinking about it, it is ahead.
Excellent. So what I'd like to do is ask Natalia, to add on that from the EU perspective, and then just sort of get, final conclusions from Ami and Luke on the matter. Natalia, how do you view the current state of regulation in the EU in terms of the current environment?
I think I agree with what has just been said. We're moving forward at a rather quick pace right now. MiCA came, okay, it only applies to crypto assets and not to financial instruments, and then the pilot regime has been launched on March 2023, and that tackles the issues related to settlement and trading. So I think we'll be surprised in the next 2-3 years to see a lot of new infrastructures emerging. As mentioned by Albert, there have been efforts locally in France to adapt our local legislation, in Italy recently, also in Germany with the e-security regime. So we are really, I think, moving quickly, and all the local jurisdictions have, their own regimes with, for example, in Luxembourg, the dematerialized securities law, which provides for a third form of securities not registered, not there, but dematerialized, with a central account keeper that, plays the role of sort of a settlement to a certain extent. So we'll see a lot of things emerging. And hopefully the next step will be seeing the infrastructures that also match the current landscape.
So if we can jump to Ami for 2 minutes, then Luke, if you can give us your thoughts on that infrastructure, because we're hearing about, on one hand, a more mature regulatory structure, but on the other hand, the demand hasn't yet picked up. Everybody's looking at it. When is the next step is going to come?
I think probably Luke will agree with me. The business that we work in, tokenization of securities and real assets, we don't care that much about crypto. We don't deal in crypto. We use the technology to actually enact the existing. We don't need the regulation to change at all. If the regulation stayed as is, and like in MiCA, just acknowledge that it's basically the same regulation, we will be happy. I think the biggest thing you will see coming right now is this. It's not nice to say it, okay? But until now, the regulators dealt with people coming to them who were innovators, new people, crypto people, people from other jurisdictions, people they didn't really trust, people that there were a lot of scams and so on. That's one. Regulators looked at those people with some level of, suspicion, if you will. The next level is you're seeing the top 10 banks and top 10 bank exchanges and top 10 custodians coming to the regulator and saying, hey, here is what we are doing. We are actually using the technology to implement all the things that you wanted and better, and you're going to get more transparency and so on. And somehow the regulators tend to look at these players with more favorable eyes than they look at the innovators and crazy people, if you will, that invented the technology 5 years ago. So I think this is the big difference. And when you see banks go to the OCC and say this is what we're going to do, they get better treatment than a small organization nobody has ever heard of and doesn't have the reputation of understanding regulation, having risk measurements in place, and so on. So the fact that banks took a lot of time to do it is because they actually have the culture, the ability, the tools to do it properly, and now they're doing it. And regulators behave differently when they're approached by those people than the previous wave.
Super, Luke.
Yeah, a lot of things we could say, but I think it's fair to say that because in Europe the regulators are not scared about public blockchains, it's quite easy. We say we will enforce securities rules. Now with MiCA it's clear. In Luxembourg it's clear for years. And let's go. And the more the network is decentralized, the more secure it is. And regulators understand that in Europe, which is quite amazing. In the US, financial institutions want to tokenize, but they don't want to pay gas in crypto because they don't know if these cryptos are securities. It's as simple as that. So they cannot use the infrastructure by default. So as Amy was saying before, they launch their private networks. And then, of course, you need technology to link all of these networks. So I think in Europe, it's quite well advanced. Actually, we will publish in a few weeks a paper made by several law firms, all of the key players in Luxembourg, to explain that we don't want new regulations. Everything is fine, and it should work like this, with this framework, with the right token protocols, and so on and so forth. So I think it's going to be interesting to see the reactions. However, in Europe, it's we have the ESMA giving directives, and then every country is applying these directives in different ways. So it's not always easy. And for example, in Germany, they made a new license. So if you want to operate security tokens or tokenized securities, you need this license. So now, for normal securities, you have investment firms. They are regulated and they can basically do the operations. Now in Germany, you need specific investment firms with this license to perform operations, meaning that we basically switch from professionals or the financial sector to startups, techies, basically. Whereas we already have the tools to make it simple. When you use our tools, you don't need any technical background. You just need the responsibility and the business workflow to perform these operations, to maintain your registry, and so on and so forth. So sometimes it's not good to over regulate. I think in Germany they went a bit too far. They didn't need that. In Luxembourg, it's fine. You have a lot of investment firms and professionals of the financial sector who can already do all of these operations, transfer agencies, KYC agents, paying agents, registrar. All of this is working fine already. And depending on the type of securities you're making, you have different type of obligations, and third parties are needed or not, etc. So we just set up the platform depending on the type of financial instrument and who is involved in the process, and it is as simple as that. But unfortunately, yes, it's hard to put all the countries, around the same table and with the exact same rules.
Well, we're out of time, but we have a very interesting summary, which is, on one hand, the United States, we're pleading for clarity in the regulation. In Europe, some of us are saying, please, we don't need any more regulation. It's good. And in the UK, we need some fine tuning to the FCA regulations, et cetera, to get it right. But I want to just thank you.
I think we lost you.
Daniel, your audio is off.
Okay, can you hear me now?
Perfect.
Yes.
That was my cue to end the conference. And to say that we have to continue to be thought leaders. We need to educate the regulators. We need to speak to the industry. We need to show that we are the solution and not the problem. And we look forward to continuing that journey together. Some of us have worked very closely, and we look forward to continuing to partner in the future. Thank you very much for joining and for your time and your insight.
Thank you, everyone.
Thank you.
Thank you. Bye-bye.
Thank you.